Good evening, Adele. How are you? Good evening, all. Can you hear me? Okay. Welcome to the class this evening. Is Adele online? Let me just check. Okay, Adele is not online at the moment, so we can continue. Okay, those of you who are online, welcome to tonight's ILW class. Just enter your student numbers into the chat function for me, please. Students, any questions on last week's discussion? Any questions on last week's discussion before we start? No questions for me? Don't like it when people don't pose questions. Okay, I think last week we spoke about criminal disputes and just see something quickly. Okay, I want us to go to we've spoken about this already, but I'm just going to go over it again. Before we go over to the revision, I want us to go to page 249, paragraph 12.7. We're going to look at the most important courts in South Africa. Okay. Are all of us at page 279? Let's start. Okay, let's start. Okay, so you should be mindful, very mindful, that the third branch of government, which is the judiciary, okay, our judicial power, okay, South Africa's judicial power is vested in our courts, okay. Now, in our South African court system, we distinguish between two types of courts. Okay, we distinguish between two types of courts. Firstly, we distinguish between superior courts and lower courts. Okay, we distinguish between two types of courts. Yes, Michelle, but I'm at page 249. Okay. Okay, students. So, chapter 8 of our Constitution. Chapter 8 of our Constitution deals with courts in South Africa. Okay, and chapter 165 speaks about the fact that the judicial authority is vested in our courts. Section 166 lists the courts in order of their authority. Okay, so our apex court, okay, our apex court is the constitutional court. Okay, and please be mindful, the constitutional court is the highest decision-making court in all constitutional matters. Okay, the finding of a constitutional court decision cannot be appealed or reviewed. Okay, the finding of a constitutional court decision cannot be appealed or reviewed. The Constitutional Court can also, in very limited instances, okay, in very limited instances, be a court of first instance. Okay. Our second superior court is the Supreme Court of Appeal, seated in Bloemfontein. The Supreme Court of Appeal is the highest decision-making court in criminal and civil appeals. Highest decision-making court in criminal and civil appeals. Then our high courts, okay, also a superior court, okay, we have a seat of the High Court in each province of the country. We have 9 provinces. We have a seat of the High Court in each province. There are certain provinces, I know, the Eastern Cape province, Gauteng province, okay. I must check the other provinces, but those 2 provinces have more than 1 seat. Okay, like Gauteng, the North Gauteng and South Gauteng High Court, where there's a seat in Pretoria and there's a seat in Johannesburg. Okay, so these are the 3 superior courts. Okay, then we have our lower courts, which are our magistrates' courts. Okay. What you should be mindful of our superior courts, our 3 superior courts, is they have the common law power, which is now legislated in terms of the Constitution. They have the common law power of inherent jurisdiction. Okay? Inherent jurisdiction. Okay. Okay. Let's look at the following related to the Constitutional Court. Okay, here's something that I was unaware of, and I will clarify it now. There's a question from Michelle. Let me just see what it is. Michelle, I don't know what you mean by this question. Okay. Which processes does inherent jurisdiction cover?
Okay, good evening, advocate. Sorry, that question wasn't very clear.
Hi,
Um,
Michelle.
Hi. In understanding the definition of inherent jurisdiction, it says that the courts they have the power to control their own processes. So
To
if the
regulate and control their own processes, yes.
yes,
Okay.
but now
So let me give
oh
you an
okay
example.
yes please okay
Okay. Um, remember, a court calendar is divided into quarters.
okay
Okay. So the High Court can decide, or any court with inherent jurisdiction can decide how that that quarters the year should be divided, how long
okay
the recess should be,
okay so matters like
what
that.
time matters start,
Okay.
in terms of how they will deal with an urgent application, because with regard to an urgent application, it deals with dispensing of court rules. Okay, and court rules cannot just willy-nilly be suspended with, but in terms of that inherent jurisdiction, the court has the power to control all of those processes.
Okay, got it.
Okay, the
Thank you very
court
much.
even has the power, if there's application for leave to appeal. Okay, the court has the power to dismiss that application. Not
Oh,
each application for leave to appeal has to be granted. The court has the power to dismiss it, and that falls within its inherent jurisdiction.
oh, I see. Would they not?
Okay.
So then, because I thought, would there not be like the court procedures would be like the formal law? So it's very separate from formal law in how they can function in that courtroom. These seems like more like administrative.
Now our court has the power to deviate from formal.
Oh, okay.
Okay, that is what
That's what I
inherent
was
jurisdiction
asking.
is about.
Okay,
So,
they can deviate
so
from that formal law.
yes, so I
Oh,
gave you an
okay.
example of an urgent application now. Okay, in
Okay.
terms of a normal court application, there must be proper and effective service. Okay, so if someone brings an application for eviction, okay, a respondent must be served properly. Okay, but if there's an urgent application, the court has the right to dispense with service processes and hear the matter as soon as possible based on the urgency.
Okay.
Okay, so the court has the right to dispense or deviate from certain formal processes because that falls within the court's inherent jurisdiction.
Okay, that's what I needed to understand what that meant.
Okay,
Okay, thank you so much.
okay, thanks.
Okay,
Can I continue?
yes, thank you.
Okay. Now, here's some new information with regard to the Constitutional Court. Okay. I want you to be mindful of the following. Section 167 of our Constitution deals with the Constitutional Court. Now, telling us here, and this is something I was unaware of, it tells us here in the past, the Constitutional Court could only hear constitutional matters, and it was the highest court of appeal in constitutional matters. This position has changed. The Constitutional Court is now the highest court in all matters. Okay, this means it tells us that Section 167 of the Constitution has been amended, which changed this position. Okay, the Constitutional Court, this section now states that the Constitutional Court may decide one, constitutional matters, two, and any other matter. Okay, in the case of any other matter, the following conditions must be met. Okay, the Constitutional Court must grant leave to appeal, and number two, the matter at hand must raise an arguable or a debatable question on a point of law that is important to the public in general, which ought to be considered by the Constitutional Court. So, although the Constitutional Court only heard constitutional matters in the past, it is now, in theory, the highest court of appeal in South Africa in all matters, but subject to the court granting leave to appeal to hear the matter. This means that the decisions of the Constitutional Court are final and binding on all courts. Okay? So here's your first set of homework. Okay? You need to go do thorough research for me on the amendment of Section 167 of the Constitution. Okay? You need to go do thorough research for me on the amendment of Section 167 of the Constitution. Okay? Okay? Very, very importantly, students, the Constitutional Court has exclusive authority to decide disputes about the powers and constitutional status of branches of government. Okay? The Constitution refers to 6 specific matters. Okay? 2 of these matters are the constitutionality of any amendment to the Constitution and the question whether Parliament or the President has failed to fulfill a constitutional duty. Okay? The Constitutional Court also has the final decision in whether an act of Parliament, a provincial act, or the conduct of the President is constitutional or not. Okay? A person may approach the Constitutional Court directly. Okay, this is what I called, it can be a court of first instance, but a synonym for that is, this is called direct access, but an application for direct access will only be granted, okay, I said it's in limited instance only, so it's based on an application and it will only be granted if the interest of justice requires this, okay. The Constitutional Court can function as a court of first instance, a court or a court of appeal, okay. Remember, it hears appeals from the SCA as well. Okay, any questions so far? Any questions so far? Any questions for me? Muhammad has a question. Okay. Now, Muhammad, I'm going to explain this by way of an explanation. Sorry, an example. Okay. When we talk about municipal bylaws, okay, these bylaws are enacted by municipal authorities, by municipalities, okay. They have the right to enact bylaws in districts, okay. Now, remember, all laws, this includes municipal laws, are subject to the Constitution. And please be mindful of the following, Muhammad and all other students. Please be mindful that the testing of any law, okay, the testing on the constitutionality of any law, be it national, provincial, or municipal legislation is our courts. Okay? So our superior courts, all our superior courts, have the jurisdiction to hear matters on constitutional grounds. Okay? Now, I'm going to give you an example. Okay? There's a municipal bylaw in the Western Cape, okay, that basically deals with an issue that if you are caught, and this is in my view only, okay, and you can give me your views after this. This is my view only, but this view also has not been tested in any court. There's not been a test case of this nature in any court. So if it happens to me, okay, I will take this matter to court. So there's a municipal bylaw, a traffic law in the Western Cape that allows a law enforcement official, if you are the driver of a vehicle and you are caught operating a cell phone or a mobile device whilst operating your vehicle, they may pull you over, they may issue you with a fine, and in addition to issuing you with a fine, they can confiscate your cell phone, okay? And you only pay that cell phone. You only get that cell phone once you pay another fine or a release fee, okay? So in my view, okay, this amounts to a situation of double jeopardy, okay? Firstly, you have the constitutional right to own property, okay? And a cell phone amounts to property, okay? You have a constitutional right over there, which is a very strong right. And yet there's a law that allows a law enforcement official to confiscate your private property without a court order, okay? And then issue you with a fine, and then you need to go pay another fine at the city, which is known as a release fee, to go get your cell phone. So in my view, you are punished twice. It's like a double jeopardy. You are punished twice for the same offense. Okay, I don't know if it makes sense to you. So you already issued with a fine, but yet your private property is being confiscated. Then you need to go pay a release fee to get your property back. Okay, that to me is unconstitutional because it's, in my view again, it's an arbitrary. Okay, it's very arbitrary, one-sided, where property rights are violated. Okay, no provision is made for the Audi Altem Partem rule, nothing. It's very arbitrary. So if that should happen to me, I will bring an urgent spoliation application. Okay, and the nature of a spoliation application is for you to be put back in the situation prior to when the spoliation of property happened. Okay. Muhammad, I agree with this Muslim call to prayer and noise. I believe that it's also related to city bylaws and stuff like that, but none of these issues were ever tested in court. Okay, so the only testing ground for these issues, because here we're looking at the the right to freedom of expression, right to religious practices that are now curbed and regulated. Okay, remember, only Section 36 can be invoked to limit constitutional rights. Okay, and the testing ground for that, the fairness of how Section 36 is applied, the testing ground for that is our Constitutional Court. Okay. Any other questions or comments before I continue? Any other questions or comments before I continue? Okay, let me see if there's questions. Angela, please go read up on a spoliation application. Okay, it's called the Mandament of Spoli. Please go read up on that and come and explain to me. You can submit a written piece to explain to me what that means. Okay. Let's continue. Let's continue to the SCA, the Supreme Court of Appeal. Okay. Section 168 of our Constitution deals with the Supreme Court of Appeal. These sections I'm referring to, students, you need to know them. You need to know them verbatim. Okay, and you need to know what they mean. Okay, you must already know that you must supply me with a written piece on the amendment of Section 167. Okay, so Section 168 deals with the SCA, and the Supreme Court of Appeal has the jurisdiction to decide appeals within the whole geographical area of South Africa. Okay, the SCA may decide civil, criminal, and constitutional matters on appeal. In its judgment, the SCA may declare an act of parliament, okay, a provincial act, or the conduct of the president unconstitutional. It is compulsory that the SCA refer such a court order to the Constitutional Court for confirmation before it can come into force. Okay? Now, the Supreme Court of Appeal functions only, very importantly, students, it functions only as a court of appeal and never a court of first instance. Okay? The court hears appeals from the high courts. Okay? From the SCA, a further appeal can be made to the Constitutional Court. Okay? Any questions related to the SCA? 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 No? Okay, let's continue. Let's go to our high courts. And students, Section 169 of our Constitution deals with the High Court. Okay? The Superior Courts Act 10 of 2013 regulates the jurisdiction of the High Court, okay? Each High Court has the jurisdiction to hear cases within its own specific provincial area, okay? As I told you, in Gauteng, there are two High Courts. For example, the seat of the High Court in Pretoria is known as the North Gauteng High Court, while the seat of the High Court in Johannesburg is known as the South Gauteng High Court. Very, very importantly, a High Court may decide any civil and criminal matter which is not assigned to the court, okay, as well as any constitutional matter except a matter that only the Constitutional Court may decide, okay? Although we say that the High Court may decide all civil and criminal matters, the court may be limited to do so in terms of practice, okay? This is in terms of the court role and the amount of matters that is allowed, okay? So, for example, in civil cases, a High Court may only hear cases where substantial or large amounts of damages are claimed. Okay? There's some interference there. Who is that? Wendy, please switch off your mic. Okay. So in terms of criminal matters, the court will only hear serious criminal matters. So the normal non-serious criminal matters like shoplifting, theft, assault, GBH, stuff like that, it won't be heard in a high court. Those will fall into the jurisdiction of magistrates court. Okay? So also very, very important, similar to the SCA, the High Court may declare an act of parliament, a provincial act, or conduct of the president unconstitutional. It is also compulsory for the High Court to refer such an order to the Constitutional Court for confirmation before it comes into force. Okay? So, also important, the High Court can function as a court of first instance, a court of appeal, or court of review. Remember, a matter in the lower court, okay, a criminal matter or a civil matter in a lower court, a magistrate's court, can be appealed to the High Court. It can also come for review to a High Court, okay? So, as I'm telling you, as a court of appeal, can hear appeals of cases that were first heard in the magistrate's court, okay? From a High Court, a further appeal can be made to the Supreme Court of Appeal, okay? Any questions, students? Any questions?
Hi, Advocate. I've got a question about the Supreme Court of Appeal.
Michelle, yes, I'm listening.
Yes. Okay, so I was just reading a case from the SCA. It was on appeal, and it seems as if they took about 2 days to make a decision. So I just wanted to confirm what happens in that Court of Appeal. Does the representation have to go to Bloemfontein? Who needs to actually be in that court? And do they have to check all of the sources, international law, whichever sources? I mean, how is it possible to do that
Remember,
in such a short
court
period of
of
time?
appeal. A court of appeal, okay, only works with the record of the court of quo. Okay, so if a matter is appealed, okay, the record of the court of quo, remember, in terms of the law, all court proceedings must be recorded.
Yes.
Okay, so that there is a record. So once a matter goes up for appeal, okay, that record is transcribed and the record is sent to the SCA. So the judges in the SCA only work on the record. Okay.
Okay, so it's not set up like a normal high court.
And if there's a trial, if there's a hearing, okay, it's based on the information contained in the record only.
Okay.
Okay. So it's based on the record only.
All right. Okay. So then nobody
Okay.
needs to be traveling to Bloemfontein to appear again.
Sometimes they need to travel, sometimes they don't need to travel. Yeah?
Okay.
Based on whether they need to argue certain matters based on the record.
Oh, I see. Okay, so that could possibly take place. Okay,
So
great.
argument in terms of an appeal matter can only take place in terms of the record. No new
Oh,
evidence can be
no new
introduced.
evidence. Okay.
Okay. Yeah?
All right. Thanks very much.
Okay. Any other questions? Okay. So if there's no questions, let me continue to our lower courts. Okay. And our lower courts are our magistrates courts. And we know there are two types of magistrates court, namely district court as well as regional courts. Okay. And these are known as our lower courts. Section 170 of the Constitutional deals with magistrates courts and state that these courts may hear any matter determined by an act of parliament. Okay? That is very important. It may hear any matter determined by an act of parliament, meaning they get their power from statute. So magistrates courts are creatures of statute because they can only function in terms of what legislation allows them to do. Meaning, magistrates courts may hear civil and criminal cases, but they are restricted in their jurisdiction to decide these types of cases. Okay? In civil and criminal cases, the jurisdiction of the district and regional courts differ. Okay? So, the civil jurisdiction of a regional court, of a district magistrates court, I'm speaking under correction, I think it's 200,000. Okay? The civil jurisdiction of a regional court, I think goes up to 400,000. Okay, the criminal jurisdiction of a district court is a 60,000 rand fine maximum and maximum 3 years imprisonment. Okay, I know that um, regional criminal courts have the power to institute the Minimum Sentences Act. Okay, so in criminal cases, district courts hear less serious offenses like drunken driving, and regional courts may hear criminal offenses like rape and murder, but not treason. Okay, the sentences and fines in a district court and regional court also differ. I explained to you now, And a court with lower court status than a high court, in other words, magistrate's court, may not inquire into or rule on the constitutionality of any legislation or the conduct of the president. Also, our lower courts function as courts of first instance. From a magistrate's court, further appeal or review can be made to high courts. Okay, any questions? Any questions? Any questions? No questions. I want us to go to paragraph 12.9, page 255. Okay, so if we look at what an appeal is, okay, so if either party to a dispute, okay, if either party to a legal dispute is not satisfied with the court's decision, they may take the decision on appeal. Okay? An appeal may be lodged against the finding of the court on any point of law and or the facts. Okay? So what parties are alleging is that the court who made the finding has erred. Okay? ERRED. The court has made a mistake. Okay, to err is to make a mistake. So if parties are alleging that the court has erred, they're not satisfied with the court's decision, they may bring application for leave to appeal. An appeal may be lodged against the findings of the court on any point of law or facts. Okay? Page 256. If one of the parties in a civil dispute, okay, is of the opinion that the court has made an error in its decision, okay, in other words, the party is not satisfied with the decision, the party can lodge an appeal or apply for leave to appeal to a high court. Okay, in a criminal matter, okay, if in a criminal case, okay, a party is not satisfied with the court's decision or judgment, this is normally a guilty judgment, he or she may lodge an appeal against either the proceedings as a whole or the proceedings in part, meaning either against the conviction or the sentence or both. The state may only appeal in certain circumstances. Okay, remember the state brought an appeal in the Oscar Pistorius case. Okay, when it was decided in the High Court. Okay, when Oscar Pistorius was not found guilty of murder but of culpable homicide, the state appealed that judgment in the High Court. Okay, the appeal was upheld and the conviction was changed from homicide, culpable homicide, to murder. Okay, okay. On appeal, Michelle, I want you to take note of the following. On appeal, the court does not listen to oral evidence of witnesses about the facts of the case again. The court only studies the typed record of the proceedings of the court that originally made the decision and then listens to arguments made by the legal representative. Okay? The higher court considers whether the lower court made the correct decision on the facts and the law. If the Court of Appeal decides to uphold the appeal, it means that the decision of the original court is set aside and the appeal is successful. If the Court of Appeal dismisses the decision, it means the decision is confirmed and the appeal is unsuccessful. Okay? We know that when a matter is on appeal, the parties are called the appellant and the respondent. Anything on appeals, students? Anything on appeals? Anything on appeals? Okay. Angela, I'm answering your question now, and that question is no. Okay. Let's look at what reviews are. Hey, Muhammad, I'm going to look at your question now. Give me a second. Muhammad, yes. Okay, the Labor Appeal Court is a special court. It has the jurisdiction of the SCA, so it's the highest decision-making court in labor appeals. Okay. Let's look at the reviews. Okay? So, students, a review is the process whereby the proceedings of lower courts in both civil and criminal cases are brought before the High Court in respect of irregularities occurring during the course of such proceedings. Okay? So, yeah, we don't say the court has erred or the court has made a mistake, but here we are referring to irregularities occurring during the course of proceedings. So, if a party is not satisfied with a method or procedure by which the court, in arriving at its decision, then the case may be taken on review. So, Section 22 of the Superior Courts Act sets out the grounds upon which the review proceedings may be brought. Okay, and the grounds include absence of jurisdiction, interest in the cause, there's bias, prejudice, favoritism. There can also be malice or corruption of the presiding officer. That is a serious allegation. There's gross irregularities in the proceedings. In a criminal matter, the admission of inadmissible or incompetent evidence or the rejection of competent evidence by the lower court. Okay? So here's an example for you students. Here's an example. When the proceedings of the lower court have not been translated properly by an interpreter, or if the accused has not been given the opportunity to present his or her own case, these constitute a gross irregularity, okay, in proceedings which are grounds for review, okay? In a review, a court may go beyond the record of the original court, as the irregularity may not be apparent from the recordings. If a higher court finds that there has been irregularities, it will usually refer the case back to the original court to hear the case again and correct the proceedings. In certain instances, it may decide the case itself. Okay? Any questions on review? Any questions on review? Any questions on review? Okay. No questions. Okay. So, what I'm going to do now, students, I am going to let me just go to the beginning of the study guide. Muhammad, if we take a matter on review and new evidence comes to light on how we can remember, if a review succeeds and the High Court finds that there was gross irregularities, the matter needs to start de novo. The matter needs to start from over. So if the matter starts from over, we technically say that the matter starts from new. So if the matter starts from new evidence may be introduced. Okay? Does that answer your question? What kind of? Muhammad, can you speak to me? Unmute your mic and speak to me. I don't like it when people say to me, kind of. What does kind of mean? Lawyers don't speak of kind of. I either answer your question yes or no. Muhammad, are you going to speak to me yes or no? Okay, students, I want us to do the following. Muhammad doesn't feel that he wants to speak to me, so I can't force him to speak to me.
Hello.
Yes. Muhammad, I can't hear you. Muhammad, I still can't hear you.
After the judgment. Okay, I'll type.
Okay. Okay, students, I want us to go to the contents page. Okay. The contents page of your study guide, and that is page number 3. Okay, go to page number 3. I just want to indicate to you how we are going to do revision. Okay. Michelle, can you just confirm for me on which date the exam is? Is it the 2nd, 3rd, or 4th of
Let me
December?
just the 1st of December. ILW is on the 1st of December.
Okay, let me just go to my calendar. So the 1st of December is on a Tuesday. Okay. So students, we at the 9th of November. Okay. So next week is the 16th of November. Please be mindful of the following. Next week on the 16th of November, I'm going to do learning unit 1, 2, 3, and 4. Okay. Learning unit 1, 2, 3, and 4. So go through learning unit 1, 2, 3, and 4. And then also indicate to me what difficulties you have. Okay, that's on the 16th. On the 23rd, we will do learning unit 5, 6, 7, and 8. Okay, on the 23rd, we will do 5, 6, 7, and 8. Okay, and then on Saturday, the 28th, I will confirm the time. On Saturday, the 28th, I will confirm the time. I will do 9, 10, 11, 12. Okay, 9, 10, 11, 12 on the 28th. The 28th will be a 3-hour session. Okay, on the 28th, I will do the last chapters, 9, 10, 11, 12. And then on Monday, the 30th, okay, I'm going to do 2 hours exam technique, and just final revision. Do all of you have that, students? Okay, do all of you have that? Just give me a yes. Okay, Michelle and Queen has that. And then students, my last announcement, because I'm not going to start with revision now. I'm going to give you an opportunity to start first before I go through the things. Okay, students, for this week, I'm working out of Johannesburg and Pretoria. Okay, I'm out of Cape Town. I'm working out of Johannesburg and Pretoria, so my work calendar is quite tight. So I'm having the class tomorrow night, but for anything else, when you submit work to me, when you request one-on-one sessions, I will only be available for that from Friday, the 13th of November. So late on the Thursday afternoon, on the 12th of November, I'll start responding to your emails. I'll start responding to your queries for individual sessions, but those sessions will only take place from the 13th of November. Okay, when I'm back in Cape Town. Students, any questions before we log off? Any questions before we log off? Any questions before we log off? Okay. One more announcement. If you see the chat function, you will see between the messages of myself and Muhammad, there's a link from Adele Blacker for the recordings of the session. There's a link from Adele for the recording of this session. And if you go up in the conversation, there's also the link for you to book a one-on-one session with me. Okay, remember those one-on-one sessions I'm available from the 13th of November only. Michelle, thank you. I will enjoy Gauteng. I love the city. I love Gauteng and Pretoria. I don't know why I'm still a Capetonian, but for some reason I prefer Gauteng and Pretoria. Students, if there's no questions, we will conclude for tonight, and then we will speak to each other tomorrow night for skills for law students. Okay, thank you, Muhammad. Thank you, Queen. Thank you, Michelle. We speak tomorrow. Okay, have a good evening. Bye.